SJC-13906, Commonwealth of Massachusetts versus KalshiEX, LLC.
Okay, Attorney Mainland.
Good morning, Chief Justice Budd, members of the court, Grant Mainland for KalshiEX, LLC. May I begin?
Yes, please.
Event contracts, including sports event contracts, are derivatives. As the Third Circuit recently held, they are swaps that trade on nationwide exchanges. Their prices are set by the trading decisions of millions of individuals and businesses around the country. Those prices fluctuate constantly up until the very moment of resolution of the contract when the event does or does not occur. And like all exchange-traded derivatives, event contracts generate tremendous predictive power as to whether something will or will not happen. And like all exchange-traded derivatives, event contracts offer an opportunity for a trader to earn a return. In this respect, these products are no different than any other derivative. These exchanges are overseen by a single federal regulator, the CFTC.
In what way do they differ from what would colloquially be known as a bet?
I think they differ in a number of ways, Your Honor. The first is that these are exchange-traded instruments where the pricing on the contracts is set purely by supply and demand, who is buying, who is selling out in the market, and that is constantly fluctuating in time. They are also centrally cleared through what's called a derivatives clearing organization that also is a CFTC registered entity. They are fully collateralized, and that money is held by the same clearing organization and distributed differently. And what I would say,
those would not be, I mean, at least conceptually, right? If we just zoomed up one level, they would not be conceptually incompatible with what we would historically understand to be a bet or a wager.
I don't fully understand the difference of historical incompatibility. I do think they are fundamentally different, and I get their intuitions that why is this any different than a bet? I think when you go into a casino and place a bet with a sports book, that's a bilateral transaction between you and the sports book where they are setting the odds, they are setting the pricing. And I think we all know when one engages in that behavior on a regular basis, the bettor is not going to be on the right side of that. I think it's completely different with respect to derivatives transactions. And what I would say, Your Honor, the only
completely different, really completely different. For someone who wants to bet on a game, this is a way of betting on a game, right? I want to bet on whether Tatum makes a three-point shot. This is a way of doing it if you put it out there, right?
I get that. Certainly, you can take a position on whether something's going to happen. In a game
you can if you want to gamble on a game. This is one way of doing it, right?
If you want to take a position on what we can use whatever terminology, and I don't want to get hung up on this.
I just want to push you on 2 points. So, sure. This does seem to have a major aspect of sports gambling to it, and 2 points for me. The major policy question doctrine from the Supreme Court says, if you're making a major policy decision, Congress has to speak clearly. And secondly, sports gambling is huge. So why isn't this the elephant being put in the mouse hole, using Justice Gorsuch's example? Because it just seems to me that if Congress was going to do this to shift sports gambling to the CFTC, it would do this more clearly and more distinctly. And the CFTC has sort of discovered this power, but it didn't know about this all. Before, it didn't think it was covered. So with that, those are questions, not answers.
Right. Thank you, Your Honor. And I want to take issue with the premise that this is just sports gambling.
I understand you can distinguish it, but if I want to bet on this stuff, I can do it this way too.
And Congress in 2010, when it passed Dodd-Frank, was well aware that event contracts might involve gaming. In fact, that's the only place, not in the definition of swap, not in the definition of excluded commodity, is there any sort of limitation on what kind of event might qualify. That's the only thing that distinguishes these derivatives, is that the underlying event happens to be a sports event. But Congress recognized that event contracts may involve gaming. And yes, it is true in 2010 when Dodd-Frank was adopted, that there was discussion around this idea of we don't want derivatives markets to become a place for gambling. But a lot has happened since then. And what's important about that is even the senator who made that comment, even that senator, Senator Lincoln and Senator Feinstein had their colloquy on this back in 2010. The question is, not what did they say in connection with that, but what did they do with the statute? And what they did is they gave this authority to the CFTC. The special rule is very clear that there are enumerated events.
But when we read through that whole legislative history, we're not going to find, we're giving sports gambling to the CFTC, right? We're not going to find anything like that. And again, gambling is something that the states have historically regulated, right? Supreme Court also says to us, we're not going to read out a state power unless that's clearly done too. So again, I just feel like you're swimming upstream here.
I don't think so, Your Honor, because the Congress knew what it was doing. It didn't have to be speaking in terms of handing over the entire gambling industry to the CFTC, and it's never been our position. You're going to hear this a lot from my friends on the other side, that this is a radical change in federal-state relations, that all gambling regulation is now being run by the CFTC. That has never been our position, and it's clearly not what's happening.
I'm confused, though. What is your position then?
Our position is that transactions on DCMs, even if the underlying with respect to those derivatives transactions happens to be a sports event, are clearly preempted by Section 2A1A of the Commodity Exchange Act. And I think—
So let's turn to that. What do you mean clearly preempted under that Section 2A?
I think the plain text of Section
Do you think
2A1A—
it's express preemption?
our position is it is express.
Why? Can you explain that? Because I agree with Justice Kafker's observation that one would have thought that if Congress was going to take some role in sports wagering, it would have been more explicit other than this colloquy between Lincoln and Feinstein.
Well, Section 2, so those are a couple different things. 2A1A, our position is that's express preemption because—
Why? Because usually when Congress expressly preempts something, it says, not in particular words, but words different than exclusive jurisdiction. That to me sounds like, as between CFTC and SEC, this part is with the CFTC.
So the words of the statute expressly reference state law and the jurisdiction of regulators under state law. That language would be—
Do you have any examples in all of the USC where exclusive jurisdiction was a method of preemption over state authority?
I do. So there are two cases where merely the use of exclusive jurisdiction by itself—
Yeah, Congress has used that type of language to indicate explicitly, as it must for express preemption, that it intended to take away what is traditionally a state function.
Yes. So there are two cases. One is called Slaney. The other is called Heart of America Grain, where just exclusive jurisdiction was used in the statutory provision. It was found to be preemptive, and I'd be happy to— my colleague can maybe help me with the citations to those. But what I really want to emphasize, Your Honor, is it is not just exclusive jurisdiction that's referenced in 2A1A. It goes on in the savings clause to say, except as here and above provided.
But that's circular because we would have to conclude first that exclusive jurisdiction was an explicit indication by Congress that it meant to preempt something that is traditionally a state function.
So I guess where I come at this, Your Honor, is it uses the word supersede and limit. Supersede is essentially a synonym for preempt, and the Supreme Court has been very clear that there are no magic words requirement. There no particular formulation is required.
But the Supreme Court has also been really clear that the preemption, if it's expressed, needs to be quite explicit, especially in areas where traditionally the states have taken the lead.
Well, every court of appeals that has looked at Section 2A1A and whether it has preemptive effect has found that it does. The First Circuit has found that, the DC Circuit has found that, the Second Circuit, the Fifth Circuit, and a state Supreme Court, the state of Arkansas, found that in 1977. So all of the interpretive authority with respect to Section 2A1A finds it to preempt state law. There's that. And then in 2010—
None of those except for the Third Circuit is about gambling, right? None of those involve sports gambling. Those involve classic futures contracts or swaps or trying to figure out whether a swap is also a security, right? It relates to that.
Well, true, sports was not involved. I will concede that, yes. But although there have been post-1974 cases where gambling charges were found to be preempted. So, and I do want to take a step back. I mean, this is all against the history, really going back to the 1880s, of states using anti-bucket shop laws and using their state laws to try to regulate the futures markets. And I think it's resoundingly clear when you look not only at the plain text, Your Honor, of 2A1A, including the savings clause that refers to superseding.
But that makes sense when you're dealing with futures. It's the commodity trading futures, right? I mean, that's the core of their jurisdiction.
Well,
Sports betting even is something just huge, as emphasized by your client's rapid increase in income. It just seems different, I guess, but.
I can understand the intuition, Your Honor, but I don't think there's a principled basis for drawing that distinction. I think the only thing that differentiates these products is the underlying. And the Commodity Exchange Act does not purport to draw differences between what kind of events qualify and do not qualify, except in one spot.
So I have just if you could back up for a second. Sure. I know you started on swaps and what they are, and I know that it's defined, but and I'll admit, uneducated layman's view of a swap is usually something that you exchange predictability for risk. Is that really what's happening here in the sports event betting?
What I hear, Your Honor, to be asking is, aren't these instruments all about hedging, and don't they have to be about hedging? And I think the answer to that is there used to be an economic purpose test that was in the Commodity Exchange Act. That was removed by Congress in 2000 in the Commodity Futures Modernization Act. And I would commend to the court the Supreme Court's Curran decision in 1982, where Justice—
I'm familiar with the Curran decision.
Right, and Justice Stevens goes on at length about the importance of speculation and the fact that there may be plenty of people in any futures market who have no hedging purpose whatsoever, but their participation in the market is what enables hedging. And hedging is not only certainly a possibility with respect to these markets, but we know it's happening. We reference Game Point Capital in our briefing, which is an insurance-related company that had been looking to offset its sports-related risk using reinsurance markets, finding it extremely expensive and cumbersome to do that, and is now using Kalshi. I have in mind the recent— I like to run marathons. I know Boston is a big running city. The London Marathon recently, there was not only did someone win that, as is always the case, but also ran it in under 2 hours. So a lot of these sports-related contracts have to do not only with the outcomes of events, but also player performance. That was a remarkable player performance. And what my first question was, what kind of shoes was he wearing? Because people are obsessed with these super shoes. And it turns out the shoes he was wearing were selling for $500, are now selling for $4,500. There are certainly consequences that can be hedged, and that this is a gigantic industry in our country. I think everyone knows that. And the statute speaks in terms of potential financial and economic consequences, not actual, and certainly not serious, like my friends on the other side said in their brief, that there needs to be some sort of serious consequence.
I had trouble following the potential financial, economic, or commercial consequence here, because it's a bet on a bet. So I'm just trying to get a sense, what is the consequence that we're talking about, that the sports team is going to affect the value of the sports team? I'm confused by that, because I get when you're hedging a bet on a future or even inflation, but I don't see what is the consequence here. Or even your race example, you're betting on the value of the shoe, that the shoe's value is going up. I'm confused.
No, you're betting on player performance. So, and I don't know whether I don't.
Well, what is the economic consequence?
The example they used was the 500-foot home run.
Mm-hmm.
That has no impact on the game. It's one run. So that's why there's an economic part of that.
Sure. With respect to those kinds of metrics, I think unusual events within sports are events that tend to drive engagement, right? And so there are a lot of different constituencies and a lot of different stakeholders with respect to these games, including advertising dollars, including
So the
media.
color of the Gatorade has something to do with economic?
I don't think in fact, the color of the Gatorade, we've conceded, and I think is a good example. The color of the Gatorade isn't really going to, it's really a sort of random thing, right? And so I mean, this is one limiting principle, is the difference between an extrinsic consequence and an intrinsic consequence. We can see that if the only consequence is that someone's going to win or lose money in connection with a transaction, that's not good enough, because that could be true of anything.
So
But it does have.
Why isn't that us? Why isn't that this case?
Because all of these transactions, all of these swaps do have real consequences out in the world. That could be in hospitality, that can be in travel, that can be certainly with respect to advertising.
Excuse me, where in the record have you substantiated what you just said?
So the reference to the Game Point Capital example is a concrete example of actual hedging. We didn't have any discovery or any kind of evidentiary hearing in the preliminary injunction proceedings below. So, and the other thing that I think is
Well,
important.
you put in an affidavit all about the harms that would befall various entities if a PI were granted. And in that affidavit, I didn't see anything about harms to entities or people who are trying to hedge risk, and as a consequence of the PI will be unable to hedge risk. Is there anything in the record that actually does go to that point?
Other than the Game Point Capital example, I don't think so. But I will say, Your Honor, that affidavit was offered in support of harms to the company in connection with evaluating the equities of entering a preliminary injunction. We weren't making the point that affidavit was not offered in connection with this financial economic consequences issue. And the other thing I think is really critical here, and I want to be really clear on this.
Can I push you? Because from what and again, I don't fully understand these things, but there are bets on each side of this thing, right? Some are going to win and some are going to lose. How does that how are you, both sides are hedging against each other on a bet, a pure bet. So it's not like they're hedging against inflation or they're hedging against a fire risk. I'm just confused by where the economic consequences are.
So various business entities out in the world and even individuals have exposure through their own business dealings to sports. And this is price discovery. What these markets are telling you, markets are very good at putting a price on a thing. And the reality is, and this is something that the Commonwealth can't get away from, like it or not, excluded commodities include events. Events are part of the Commodity Exchange Act. We can't write that out of the statute, and there's no limitation that says the event in question cannot be a sporting event. So that is
But I
commodity.
think Justice Kafker's question, and I'm sorry to interpret for my colleague, but it's what is the economic, commercial, financial consequence of the sports event? I mean, is it the case then that that any industry that has related economic value then automatically meets the definition that you're positing? Because the consequences are not the consequences of the 500 hit. It's the consequence of New England Patriots, right? Whatever. Is that your position, that any time there's some industry that is valuable in any way, it meets the definition of swap when you bet on it?
I don't think it's sufficient for it to just be valuable, but I do think if there is business exposure to these events, and there certainly is, in connection with a team where performance bonuses may have to pay out, and that's the Game Point Capital example, that company ensures performance bonuses that need to pay out when a team wins or maybe when it loses. That's real economic exposure there. And I really do, the only concern I have with this exchange is that.
How do we separate out of these prop bets then?
So prop bets are generally sort of proxies for overall player performance. So when I talked earlier about a market, and again, I don't know whether this market existed, but let's just take it as an example. Will someone run a marathon in under 2 hours? That's a player performance question. What people call prop bets tend to relate to, like, how is someone performing? So is LeBron James performing better or worse? How is that going to affect the economics of his contract? And it only needs to be.
What about whether or not the chain gang is going to come out and measure for a first down in the Super Bowl?
Obviously, it can get very granular, and are there line drawing exercises there? Probably. But what I would say, Your Honor, is the definition of swap was given to the CFTC by Congress. When Congress passed Dodd-Frank, it adopted, and this is critical, I really want to emphasize this. When Congress passed Dodd-Frank, unquestionably, it adopted and enacted a very broad definition of swap. I think we can all agree that the definition was broad.
But CFTC didn't think it covered sports until the turn in the administration, right? They didn't think it covered it, right?
I don't think the issue was presented.
There's some, again, he's going to stand up and point to some document in this record. I thought this is a change in position of the CFTC itself.
It is not a change. Well, first of all, the question is, what is the position? Is the position on whether gaming is regulated by them or whether they have exclusive jurisdiction?
I understand betting on all kinds of commodities is clearly covered. It's sports gambling.
And I would submit, Your Honor, that when Congress gave event contracts involving gaming, and it's an open question whether sports event contracts involve gaming within the meaning of the statute, but when it gave that to the CFTC, it was in no one's mind that states would somehow be able to jump in and regulate it because the underlying happens to be the same as a whole world of sportsbook regulation that they engage in today. That business is going quite well. We sometimes hear, sky is falling sort of arguments about, well, if Kalshi is right, this is all going to move on to DCMs and there will be no tax revenue, there will be no sports betting, and
that's really that's not really our issue. You were before I think I interrupted you. You were going to say something about how nervous this discussion had made you about something, and I'm concerned.
I'm nervous.
I'm concerned.
No.
Well, what are you concerned
I really
about?
To get across is
Yes.
the importance of the structure that Congress created in 2010, adopted a very broad definition of swap, but then not only authorized the CFTC to go further define swap, but directed it to do so. And it did so in recognition that this is potentially going to sweep in stuff that isn't really what we want to be giving to the CFTC. So insurance is a good example.
Sorry, excuse me, can I interrupt you there?
Sure.
So the effect seems to be that you're saying Congress delegated to the CFTC, choosing which areas of state law the CFTC was going to preempt by allowing the self-certification of contracts to continue on DCMs.
I think that's right, yes.
So you think that Congress authorized the CFTC to preempt any sort of state law that might render a transaction illegal?
Well, I think Congress is the one who did this in 1974, full stop. I mean, there really is no ambiguity.
1974?
Yes, because event contract, so transactions.
That's going to be a hard one to, I can understand the broad definition of swap in there, but 1974, you think Congress gave CFTC the authority to regulate gaming?
It defined
sports wagering?
So our position is not that they
Okay,
give over sports wagering to the CFTC. That has never been our position. It's not our position. But what it did, and so this really comes down to how do you define the field? And the irony here is it's the Commonwealth that's defining the field extremely broadly because they know if it's a targeted definition, which is the actual definition used in 2A1A, then all of these sort of how can it be type arguments really have no bearing. And the other thing I want to mention is it's not just
the field.
What the field is transactions in futures or swaps conducted on a designated contract market. And it's undisputed that we are a CFTC designated contract market. It's undisputed that
I think that's why the discussion earlier was about whether or not this is a swap.
Well, why
the event has economic, financial, or commercial value associated with it.
And I hear the court's skepticism on that, but
I'm asking questions. I don't think you should read any skepticism into it. I've read your briefs. I have questions.
Understood, Your Honor. Thank you. And what I would say on that is with respect to the further definition of swap, the CFTC was given the authority to further define this. This isn't the CFTC. This isn't sort of a Chevron or Loper issue where the CFTC is interpreting a ambiguous statute and we're asking the court to give deference to the CFTC's interpretation. It itself further defined swap. And what it did not do, Justice Stewart, it did not expand its authority by defining swap more broadly or pulling in things like insurance or pulling things in like regulated licensed sports books. What it did, if anything, was pull back on some of these gray areas. And it did so with a principle of have these historically been traded on organized exchanges. And so one example that I'll give you is that further definition of swap regulation, which by the way is a 159-page regulation. I mean, this is a classic example of Congress giving authority to an agency that has expertise in these kinds of markets to further articulate what the scope of the activity is. This is very powerful. That
CFTC has expertise in sports wagering?
CFTC has expertise in running markets, and these are...
Well, okay, granted, that's not the same.
Well, there may be, so there are a wide variety of things that come through the derivatives markets. And I don't think anyone would say you're required CFTC to be an expert in agriculture, an expert in metals, nor are they required to be an expert in sports. And to the extent these evolutions in these markets.
No, but that was your position, that the CFTC was an expert in these things. And so that was my question.
Well, my point was on swaps.
But let's talk about this case, about sports wagering.
Well, so... And that's what I was getting to, which is that in the further definition of swap, one of the core principles of what separates out a swap from some other kind of product that may have some economic similarity is has it historically been traded on an organized exchange. And that is true with respect to swaps. And these event contracts from their inception have always been traded on organized exchanges. The example that I was going to give is in the same further definition of swap rulemaking, the CFTC dealt with what are called credit default swaps and bond insurance. Both of those pay out if an obligor defaults. So, but one is a swap, a credit default swap. The other is so-called financial guarantee insurance. And they can be identical from the point of view of the person who's the beneficiary of the insurance or who purchased the CDS. But nonetheless, the CFTC found we have to draw lines in some of these gray areas, and financial guarantee insurance has never been traded, just like sports books. I mean, there is no price discovery with respect to the terms that a regulated sports book is offering to someone who walks into its casino. That is not true of the commodities that are trading through DCMs, including sports-related event contracts.
So, but here, the only CFTC action that exists is that it's non-action, right? These are self-certified contracts. There would be no argument whatsoever for preemption here, but for that Kalshi has listed and self-certified these contracts. So your argument for preemption entails a reliance on the CFTC's non-action, despite its 4011 regulation, not kicking these off the DCMs. What is your best case for preemption of state law on in those kinds of circumstances?
So I need to push back on the idea that it's non-action. In fact, there was actual action in connection with their initial listing of sports event contracts in January of 2025. The CFTC utilized what's called Regulation 38.5, which enables it to ask a registered entity to provide a demonstration of compliance with respect to the proposed contract's compliance with the CEA.
Is that required for all or not?
No, it's within the discretion of the CFTC whether to ask about that, and the CFTC did ask about it. And Kalshi provided further documentation, further analysis, and included in that analysis was Kalshi's understanding that this was not, your Honor's alluding to 4011. It expressly addressed the question of whether this was permissible under 4011. And I guess you could say that coming out of that, there was non-action. But I mean, that is the way that the Congress set up the regime here. Self-certification is a congressional creature, not a CFTC creature. So I don't think...
No, but it's important vis-a-vis preemption, because usually, and certainly if we're in the world of implied preemption, we need a clear indication from Congress. And obviously, who chooses to list what on a DCM is not a clear indication from Congress.
So a couple of things on that. The clearest indication to my mind is the special rule itself. Congress contemplated that there would be event contracts that involve gaming. And let's just stipulate that these contracts involve gaming. We could even go so far as to say...
Well, you certified to the FTC that they do not involve gaming.
No, that was not...
Didn't you have to certify as part of your self-certification that these did not violate 4011?
4011, our interpretation of 4011, as we've explained to the CFTC, and the CFTC has put in briefs in a lot of these different matters, agreeing with it is that 4011 has two components to it. Does it involve gaming, and is it contrary to the public interest? There has never been a public interest review with respect to sports-related event contracts. There has been with respect to election-related.
So it's incorrect that you had to self-certify that the contracts did not involve gaming?
I'm not remembering whether we had to I don't think self-certifying, that we had to self-certify compliance with the CEA and CFTC regulations, and we definitely
And
self-certified.
4011 says that all contracts involving, quote, gaming are not allowed, correct?
Well, so 4011A does say that.
So I'm confused. Are these contracts involving gaming or not? Because you've certified that they're not involving gaming, but now you're granting that they are involving gaming.
I don't think, I don't have it in front of me, but I don't think the self-certification got into the granularity of does it involve gaming and is it contrary to the public interest, but rather our view that it is consistent with 4011 writ large, which Your Honor referenced 4011A, but that has to be read in conjunction with 4011C, which provides for a 90-day review. And that flows out of the special rule and the 90-day review.
Well, that's if the CFTC wants to exercise its discretion to kick something off as contrary to the public interest. But CFTC passed a regulation pursuant to its authority to enact regulations that still exist today, saying that all contracts that fall under A are unlawful or shall be prohibited.
And I understand the provision you're referring to, and we think it's inartfully drafted. My understanding is that it's being contemplated whether it needs to be revised as part of the current rulemaking that's underway by the CFTC. But even if you put all that aside, even if you take a step back and say it does, let's postulate this: sports event contracts are gaming. They are contrary to the public interest. The CFTC has determined that they're contrary to the public interest. I'm not saying any of this is true, but let's just pretend that's all true. Nonetheless, that says nothing about whether the Commonwealth can come in and start regulating them. All that says is that if Kalshi is listing stuff that the CFTC has prohibited, then we're in violation of federal law. And we might have a very significant issue with our federal regulator, including what Your Honor is alluding to. Did we make a false certification to the CFTC? There are ample remedies under the CEA to deal with that, and that extend to de-designation of us as a DCM, which could kill our entire business. So we take these issues extremely seriously, but they only underscore that this is fundamentally a federal regulatory issue. And I think the fact that, I didn't get to this, but just last Thursday—
Just find that last statement. If it is gaming, which has historically been regulated by the states, and it's contrary to public interest, it's falling right into a police power that the states have had, and that the Supreme Court has said, if you want to take away the state's police power, be express, because otherwise, we're not going to read it into that. Don't we take guidance from that?
It would have been very easy for Congress either to just prohibit these in the special rule itself, which it did not do, and Senator Lincoln herself has joined an amicus brief in the Third Circuit that says our purpose and our goal was to give this to the CFTC. But even if this assumption is that it's both involves gaming and it's contrary to the public interest, then it can't be listed on the exchange anymore. But the reality is, if it can't be listed on the exchange anymore, it doesn't exist. We don't have some other business where we're running a sports book. We're running a derivatives exchange. And so the idea that the Commonwealth has this sort of springing regulatory jurisdiction here in the face of Section 2A1A, that does say that their regulatory jurisdiction under state law is superseded and limited to the extent of trading on a DCM. I don't think that's a tenable position.
That's going to have to be your last point, I think.
Thank you, Your Honor. I appreciate it.
Time. Thank you. Okay, Attorney Cedrone.
Thank you, Your Honor, and may it please the Court, Gerard Cedrone for the Commonwealth. Congress does not casually or accidentally preempt state law, and it did not silently eliminate the Commonwealth's authority over—
The definition of swap is pretty broad, so tell me why it hasn't preempted state law. Or first, let's start with, are these things swaps?
They're not.
Why?
So Kalshi relies on one of 6 sub-definitions of swap, and that definition requires the transaction in question to involve the occurrence or non-occurrence of an event and potential financial consequences. And as we've explained in the brief, The transactions at issue here, sports betting, which are for entertainment, don't meet either of those requirements. That's true because of the definition.
Well, I mean, they pay out depending on the occurrence or non-occurrence of an event.
They don't. So as we think the district court in Nevada.
So if I place a bet on Kalshi that, the Bruins will lose, I didn't get a payout?
That's correct, but.
So I got a payout based on the occurrence of an event, the loss by the Bruins.
No, as the district court in Nevada walked through, in this context, event more naturally connotes the game itself. When you look at the relevant dictionary definitions, the loss or win or whether somebody hits a home run in the first 3 innings is not naturally spoken of as an event. And even if it is, that specific event doesn't have the type of financial consequences that we think of in this area. And I think the Ohio district.
What's your best authority for the limitation on the type of financial, commercial, or economic consequence being integrated into the definition of swap?
So the district court in Nevada in the crypto, the North American Derivatives Exchange decision, and the Ohio district court in the Schuler decision walked through the relevant dictionary definitions, and I think more importantly, explained them in context. So as I mentioned, Kalshi is relying on just one of 6 subdefinitions of swap. If it is correct that everything under the sun is an event, and anything that might put money into or take money out of someone's pocket is a financial consequence, then the rest of the definition of swap is entirely superfluous. This subsection 2 swallows everything else in section 1A, 47A.
I'm having trouble though figuring out the meaning of that last part of the clause. I mean, the example, you're betting that the one in the Jordan's furniture bet, whether the Connecticut's going to have both teams in the NCAA finals, and they're swapping with somebody to prevent the fact they're going to have to pay all the free furniture. Does that fit within the definition of this?
I think probably not. We can't dispute that there are always going to be some things that are close to the line, but Kalshi's making a categorical argument. It is saying that as a categorical matter, all of the sports betting on its platform is a swap and is exempt from state regulation. So our position is no, none of those things are swaps, but even if they could show, and we don't think they have, but even if they could show that this particular proposition or that particular proposition is a swap, that still doesn't support its categorical argument that as a categorical matter, all of these things are swaps and none of them are subject to the Commonwealth's regulation.
We need some discovery on which are swaps and which are not. So you get past a motion to dismiss on that factual question. Is that the point?
I'm sorry, I think I missed the first half of your question.
So you're suggesting that there's some factual dispute as to whether one thing is a swap or not?
No, our frontline position is that there is not a relevant dispute here. We think it's the case that none of its sports bets are swaps. I'm just making the point that we're here on Kalshi's preemption. Kalshi is resting on a preemption defense, an affirmative defense. And so even if it could show, which we don't think it has, that there are some things in the universe of bets that it's offering that are swaps, that's not enough to support its categorical argument. And I think its argument breaks down in particular when it comes to parlays. So Kalshi lets people bet on, it calls them combos, but parlays where you string together a series of individual bets. So will the Red Sox win, and will somebody get a home run in the first inning, and will they win by more than 6.5 runs, and so on. The idea that those are, first of all, that they're events, and second of all, that anyone could see any consequence of any financial consequence associated with that is just not credible. I want to turn back, I think, to where Justice Wolahojian started, which is, how is what Kalshi is offering different from sports betting? Because I think Kalshi recognizes that its argument rests on a difficult premise, which is that Congress, when it passed Dodd-Frank in 2010 to regulate the financial industry, also silently deregulated sports betting. And it also leads to some pretty odd results. If you accept Kalshi's argument, the upshot is that sports betting that takes place at traditional betting establishments like casinos or on DraftKings or FanDuel, all of those are now illegal because under Section 2E of the Act.
I don't think he's arguing that, though. He's saying that those don't involve swaps. They don't meet the definition of swaps. So that part can still be regulated, but his swaps are different.
Right. So let me address that pretty directly, because I think the distinction that he's trying to draw is,
I mean, a casino is not doing, these other entities are not doing swaps, right? They're not contracting with another private party to do exchange risk, right? They're not doing that, are they?
I disagree that there's a meaningful factual distinction between what Kalshi does and what casinos or traditional betting establishments do. And also, even if there is some difference, it's legally irrelevant. So let me start with the factual point. First of all, I think the main distinction Kalshi tries to draw is it says its transactions, it acts as a marketplace, whereas a bet at a casino is bilateral between the bettor and the casino. That's incorrect twice over. So first, the Superior Court explained at page 2 of its opinion that Kalshi has an affiliated entity that places bets on Kalshi's platform. So if I were to go on Kalshi and place a bet, sometimes the other side of that bet will be taken by a member of the public, but often enough, it's taken by Kalshi itself, by Kalshi's affiliated entity. And then also, I think it's inaccurate to say that all—
That's a separate question, whether they're doing something illegal as well as something legal. But take the more classic, are the other spots where you're not contracting with a private party to exchange risk? It does seem different.
I think even if there's a factual difference, and I'd like to come back to one other reason why I think there's not, but even if there's a factual difference, that's legally irrelevant. So if you look at all of the statutory provisions that are in dispute here, whether it's the definition of swap in 1A 47A2, nothing in that definition turns on this bilateral versus house distinction. Either way, the sports bets that Kalshi offers and the sports bets that casinos offer either are or aren't swaps. And so I think Kalshi has to live with the result that what it says for itself, if you apply the definition of swap in 1A 47A2, is true of casinos as well. The same thing goes for the exclusive jurisdiction provision. Nothing in that provision turns on this house versus marketplace distinction. And the same thing is true for state law, by the way. I mean, Kalshi doesn't dispute that it's within the scope of 23N, but just to make the point, Section 3 applies to it and to casinos, whether or not they're the house.
Can I ask
I do want to circle back.
Oh, sorry.
You keep saying that it's factually not different, and I'm still stuck on that because they don't set odds, right? They don't set odds. They operate this marketplace where users trade these contracts with each other. The prices can change dynamically. So users can sell positions before the event even resolves itself. So doesn't that really resemble more of a financial exchange rather than a house-based kind of system, like you keep saying isn't functionally and factually not different?
In certain respects, it might resemble a financial transaction, but it also, in that sense, resembles many forms of what everyone agrees is traditional sports betting. So I think the best example is most betting on horse racing in this country is organized as pari-mutual wagering, where the racetrack isn't acting as the house. The individual bettors bet on this horse or that horse, and the money is pooled. The racetrack takes a cut, and then the bets are paid out to everyone. The racetrack is not setting the odds. The odds fluctuate based on how the money comes in. So I just keep coming back to the point that it's true that there may be distinctions between specific bets on Kalshi and specific types of sports betting at casinos. But when you look at the whole picture, it is not able to draw a consistent, meaningful, and principled distinction between the bets that it offers and the bets that casinos offer. And I think this is also clear from the record in the Casella Declaration that we cite, or that we include at page 230 of Volume 1, where our state investigator walks through placing a bet on Kalshi and placing a bet on FanDuel, and walks through with screenshots how it's the exact same thing. The sports bets on Kalshi look like sports bets. They function like sports bets. Members of the public understand them to be sports bets. Kalshi goes out and advertises them as sports bets, and it's profited off of them because they're sports bets.
So I don't think anyone is contesting that there is a degree of preemption that's affected by the CEA. your normal swaps, let's call them, like swaps having to do with currency rates or something, everyone agrees that states cannot regulate those transactions on markets that are regulated by CFTC, correct?
Correct.
So with respect to the scope of preemption that the CEA, everyone agrees does have, which bucket of preemption do you think that falls under? Express preemption, field preemption with respect to transactions on these regulated markets, or some other species of implied preemption like conflict preemption?
I think it most naturally fits in the conflict preemption bucket. So there's a zone of concern that the federal government has, and in certain respects, I think, for example, traditional commodities that you included in your question, there would be conflict if the state were trying to touch those things. But that's not what's happening here. And I think it's certainly not express preemption. I know there were questions that came up about Section 2A1A and whether it's an express preemption provision. It's not. I don't think Kalshi has been able to cite any example in its briefing. I don't know if the cases it mentioned here today were in its briefing, but it hasn't provided an example where Congress has used that language to preempt substantive state law.
And so just turning back to the conflict preemption, your brief sort of seems to waffle on, it says that, maybe the provision of Massachusetts law that requires all sports bets to sort of take place within Massachusetts, which clearly is intended to have Massachusetts law not violate the Wire Act, that provision may be conflict preempted.
No, our position is that it's not, to be clear. That Kalshi's argument that there's conflict preemption with respect to that provision turns on this impossibility notion. It says that it is subject to what the CFTC calls the impartial access rule. As we've explained in the brief, and we cite that rule at page 51 and the CFTC's interpretation of it at page 51, that rule does not require a DCM to offer its product in all 50 states. It simply says that a DCM can't have discriminatory access requirements for a competitive advantage.
But doesn't it make sense that something that's on a DCM, which is this federally CFTC regulated market, that it would be really unwieldy for 50 different states' laws to be applicable to those transactions?
No, and in many instances, the CEA itself leaves room for state regulation. So there's the except as hereinbefore provided clause in 2A1A, and there's another provision that I have at my fingertips, 13A2, which carves out general state anti-fraud statutes. So the CEA itself, Congress itself, recognized that there would be room for state regulation here. And when it comes to sports betting in particular, that has been the norm in this country for more than a century. Sports betting is not a new thing. It existed decades ago, and it existed certainly when Congress passed the Dodd-Frank Act. So what would be a sea change here would not be states regulating sports betting, even when it occurs on DCMs. It would be the opposite. It would be blocking out state regulation of something that is, in all respects, a sports bet. And I'd like to emphasize just 2 points. One is Kalshi's own words. I know there's been a lot of discussion about what are these things and what aren't they. And Kalshi itself, when it went to the DC Circuit just a few months before offering the sports bets that it now offers, and we have the citation for this at footnote 6 of our brief, it said to the DC Circuit, Congress did not want sports betting to be conducted on derivatives markets. And just to gild the lily, when it explained what it meant by that, it said, the classic example is a contract on the outcome of a sporting event. So everyone for years understood that the product that Kalshi is offering is a sports bet and is the kind of thing. Did
the CFTC before the change in administration have the same interpretation, or am I misremembering something in the briefs?
No, that's correct. So we cite at page 46 of our brief a regulatory release in 2024. It's 89 Federal Register 48982. And the CFTC said, in the United States, gambling is overseen by state regulators with particular expertise. I'm paraphrasing a little bit, but the commission is not a gaming regulator. And it compared the types of regulation that happens at the state level with the types of things that the CFTC does and explained that they're not commensurate. It is not a gaming regulator. It doesn't have expertise in this area. And that, I think, brings me to my final point, and I'm conscious of the time, which is just that there are serious public interests at stake here. The legislature legalized sports wagering, but it did so with some pretty robust safeguards, like age limitations, like voluntary opt-outs, oversight of companies that are engaged in betting. And if Kalshi is correct, all of that goes away and is replaced.
What was the rationale that the CFTC articulated as to its prior position? That it didn't have authority over sports wagering?
I think it goes back to the 2012 regulation where it tried to adopt a practical understanding of what is and isn't a swap. It recognized that there's a distinction between fundamentally financial products and products that are used either for consumer purposes like traditional insurance or, as it explained later, things that are used for entertainment, which is exactly what these bets are. They're used for entertainment, not for hedging.
So it was based on, at least what I understand you to be saying, that the prior position was based on the definition of swap and that these things were not swaps.
Correct.
Okay, thank you.
Conscious of my time, for all of those reasons, we'd ask the court to affirm and keep in place the state regulations and the injunction that prevents Kalshi from operating or requires it to comply with Chapter 23N. Thank you, Your Honor.
Attorney Mainland, if you could just get those sites for the cases you mentioned in your presentation. I think it was
Thank you, Your Honor.
Slaney and Hart. Oh, I mean, you can do that in a 16L letter if you, it's
I
fine.
have them right here, if that, or if a letter would be better.
No, go ahead.
Okay, the first is, it's called Slaney, S-L-A-N-E-Y. It's at 244 F3rd 580, and the pin site is 584-85. That's a Seventh Circuit decision. The other is called Heart of America Grain. That's at 123 F3rd 1098, 1103, and that's an Eighth Circuit decision.
Okay, thank you.
Thank you.